starting in November of 1986, the federal government passed an act called the Immigration Reform and Control Act. What it did is it put the burden on employers to make sure that their employees are two things. One, authorized to be employed in the United States, and they are who they say they are. And so even if an employer does everything that employer is supposed to do with this Form I-9, if an employee makes a mistake, the employer can still be held liable. And some of these penalties can be severe. They can be in the thousands of dollars, what are called technical violations, paperwork violations. And if it's egregious enough, if there are some bad acts that this employer's been doing, there can be criminal fines. And across the country in the past few years, there have been a number of criminal prosecutions where entire companies have been shut down. Thousands of employees laid off work because of immigration violations. Make sure for every employee hired after November 7th, 1986, you have a Form I-9. Another best practice is to make sure that you have your employees' I-9s in separate notebooks, one for current employees and another for terminated employees, if that's practical with the number of employees you have. So if you have them separated, you're giving the immigration folks what they need and what you are required to give them. Make sure that you limit the number of folks that do the I-9s, that complete the I-9s for the employees to one or two, if that's practical for the size of your business. And once again, there are a couple reasons for that. First is if you have someone in the field or production person trying to complete the I-9s, that employee is trying to get folks doing the job. They don't necessarily care too much about the paperwork part of it. Another reason to have a small group of folks charged with the I-9s is that you can have those folks trained in compliance programs each and every year. And that helps if you're ever audited by the immigration folks. You can say that, we have a handful of folks that do I-9s. We get them trained up each and every year. Another best practice is to make sure that you have an employer handbook or an employee handbook, and you have an immigration compliance section in that handbook. Once again, if you as an employer is ever audited by the immigration folks, that helps to mitigate whatever penalties there may be. Do not keep an I-9 longer than you have to. You have to keep an I-9 3 years after the employee is hired or 1 year after termination, whichever's later. That doesn't mean after you hire someone and 3 years have passed, you can get rid of the I-9. It's the later of 1 year after termination or 3 years after hire. And why is that important? You can get fined for an I-9 you didn't have to have, just like a current I-9. So get rid of them, you're not going to get fined for them. We can help train employees to take a look at all your I-9s and make sure that they are in compliance to the best of your ability. They're in compliance with applicable laws and regulations. There are ways to correct I-9s that are faulty. And there's a specific way to do that. We can help train your employees to do those things. The other thing that we can do, and we have done, is external I-9 audits. We recommend that you do a self-audit annually and an external I-9 audit every couple of years. It shows that you're concerned about I-9s and taking proactive steps to make sure that your I-9s are in compliance with the applicable laws and regulations. And it's important to do this annually or at least every 2 years because laws change, regulations change, and even if the laws stay the same, the regulations stay the same, administrations change. You've seen a difference in enforcement from the Obama administration to the Trump administration. Those things happen with every successive administration. So keep those things in mind when you're thinking about immigration compliance and I-9 compliance. It's important and it's at the front of mind of many, many folks in this day and age.